Can your ChatGPT chats land you in jail? Can you actually go to jail because of what you write and talk to with ChatGPT? Let me give you a direct answer before anything else. So if you asked a question to ChatGPT, no matter what it is, you cannot go to jail. No problem. But admitting to something you actually did, that is a different story altogether. And this has actually happened with real people. And I'll tell you all about it, but in just a minute. First, the story that put this question in front of everyone this week. A federal judge just ruled that OpenAI has to hand over 20 million ChatGPT conversations to lawyers in a copyright lawsuit. This is not ChatGPT conversations going and getting hacked into, nor is it a leak. You have to give the conversations to a court because a judge said so. This is the story of how that happened and why OpenAI fought it and lost 3 times. And then once you have got all that straight, the honest answer on what any of this actually means for something that you may have typed into a chatbot yourself. Let's back up for just a moment, because this ruling didn't come out of nowhere. The New York Times and a group of other news organizations are suing OpenAI. The claim is that ChatGPT was trained on their copyrighted articles without permission, and that it can reproduce chunks of that content when you ask it the right way. This case has been running since 2023 and is now folded into a bigger multi-district case in New York with over a dozen similar lawsuits against OpenAI stacked together. But here's what really matters in this story. To prove their case, the news organizations needed evidence, not just claims. Actual proof that ChatGPT users were getting copyrighted material back out of the model. And the best evidence for that sits only in one place: real conversations from real users showing what the model actually outputs when people ask it questions. So the plaintiffs asked for chat logs, a lot of them. And this is where it starts getting interesting, because OpenAI didn't just say no. The plaintiffs originally asked for a sample of 120 million logs. OpenAI pushed back and offered 20 million anonymized logs instead, which the plaintiffs agreed to. That's already a massive number on its own. But then in October, OpenAI came back and said it didn't actually want to hand over that full 20 million sample. Instead, it offered to run search terms across the logs and only turn over whatever matched. Think about what that means. OpenAI wanted to be the one deciding which of its conversations counted as relevant. The plaintiff said no and asked a magistrate judge to force the full production. In November, that judge, Ona Wang, sided with the news organizations. OpenAI asked her to reconsider in December. She again said no. OpenAI still didn't drop it. The company took the fight to a district judge, Sidney Stein, arguing the earlier rulings didn't properly weigh user privacy against what the plaintiffs actually needed. Stein rejected that argument too, and this time it stuck. He compared OpenAI's position to a case involving SEC wiretap recordings, where the surveillance had been done secretly and without consent. Stein said that comparison didn't hold up here, and the order to produce the logs stands. So to be precise about what actually happened, this isn't one ruling, it's 3 from 2 different judges, all going the same direction, with OpenAI pushing back after every single one. Now, let's slow down a little bit, because this is the part people really need to figure out. And it's not very clear as yet. These are 20 million anonymized logs. That means names and identifying details are supposed to be stripped before lawyers see them. This is not OpenAI publishing your name next to your chat history. It is closer to a legal discovery process, the same kind that happens in most major lawsuits, where a court decides what evidence a company has to hand over. But there is a slightly uncomfortable part. A cybersecurity lawyer commenting on this case put it very well. Regardless of your privacy settings, your interactions with an AI chatbot might one day be produced in court, not because the company wants to expose you. Because if you're a party to litigation or your data ends up relevant to one, a judge can order it produced. That's true for OpenAI. It's likely true for other AI companies too, whether or not they have been sued yet. That's the real headline here. and is less dramatic than your chats are public. And more important than that, deletion settings protect you from casual access. They don't necessarily protect you from a court order. Okay, let me make this a little more concrete, because then it gets interesting, and I want to use something that really happened. And this is about a college student in Missouri, 19 years old, allegedly went out one night and vandalized 17 cars in a parking lot. 10 minutes after leaving the scene, he opened ChatGPT on his phone. According to prosecutors, what followed was a detailed conversation about what he had just done. Police later searched his phone with his consent and found the whole thing sitting there. That conversation became a part of the evidence in his criminal case. Now, here's a real distinction I want to draw out of this story. If this student had opened ChatGPT before doing anything and asked, "Is vandalism a felony in Missouri?" that alone would not have been a crime. Asking a question isn't illegal anywhere. What actually mattered was that he used the chat afterward to talk through something he had already done in detail. And that conversation sat on his phone the same way a text message would. And that Missouri case isn't a one-off. This is becoming a real pattern in how prosecutors build cases. In a Florida murder case, prosecutors included a suspect's ChatGPT questions directly in the charging documents. Things like what happens if a body is left in a dumpster and how investigators would find out. In a Los Angeles arson case tied to one of the state's major wildfires, a suspect's ChatGPT history, including a request to generate images of a fire, became part of the federal criminal complaint against him. 3 separate cases, 3 separate crimes, and in every one, the chat itself became evidence. Notice what all of these have in common. None of them involve someone getting in trouble for asking a neutral question. Every one of them involves someone using the chat in real time to talk through something they had already done or were actively planning. Legal experts describe this as functioning almost exactly like Google's search history already does in court. Prosecutors have used searches like how long to die in cold and ways to dispose of a body as evidence of intent in real murder trials. For many years now, ChatGPT conversations are being treated the same way, except a back and forth conversation tends to reveal a lot more about someone's state of mind than a single search term does. So here's the actual rule these cases point to. It doesn't matter what the topic is, vandalism, arson, anything else. Asking about something, nothing happens mostly. Narrating something you have done or are doing in detail creates a record that can end up in a courtroom if you ever become the subject of an investigation. Whether that's through a phone search with a warrant or a subpoena to the company itself. So can your ChatGPT chat land you in jail? Here's the direct answer, not the hedged one. Just asking a question? No. That's not how any of this works. And anyone telling you otherwise is exaggerating for clicks. But if you use a chatbot the way that Missouri student did, or the way defendants in these other cases did, as a place to talk through something you've already actually done or are actively planning in specific detail, then yes, that record exists and it can be pulled by investigators the same way your text or your Google history can. And there are now multiple real criminal cases on the public record where exactly that has happened. The NYT lawsuit we spent the first half of this video on is a different mechanism. A civil case using logs for copyright evidence, not a criminal one. But both stories point to the exact same underlying truth. The privacy you assume you have with a chatbot doesn't really exist in the way most people think it does. And that's the real answer. It's not a scary headline, it's actually the legal aspect of it. So that's the whole story about what happened with ChatGPT and what can happen with your own chatting with a chatbot, whether it's ChatGPT, Gemini, or Claude. So if you enjoyed this episode, do like, share, and subscribe to our channel, and I'll see you in the next one.